Hello, everybody. USCIS recently released information about significant changes to EB5 program. The Department of Homeland Security released a new rule for EB5 visas that goes into effect November 21st, 2019. I'm going to discuss those changes and what they are and how they might impact those who would like to obtain an EB5 visa. My name is Raluca Hanea. I provide immigration, estate planning, and family law services at my office in Lawrenceville, Georgia. Nina Clear, my marketing and office manager, is here with me. Thank you for all your likes, shares, and comments as they help others to see our videos.
Okay, so let's cover a few preliminaries first.
Okay.
What is the EB5?
The EB5 was established as an immigrant investor program.
And what does that mean, immigrant investor?
Someone from another country, known as a foreign investor, must invest in a company in the United States.
And if they invest, what does that give them?
Initially, they receive a conditional green card.
And what happens after they receive the conditional green card?
After a certain period of time, they must apply to remove the conditions from that green card, and then they receive a permanent green card, and then they can apply for citizenship.
Okay, and so if they don't apply to remove the conditions, do they need to leave the United States?
Yes, because they lose their status.
Okay. And does the green card apply to any family members?
Yes, it applies to derivative family members, which we have talked about before.
Will you remind us what that means, derivative family members?
Yes, your spouse and children under 21 who are unmarried.
Okay, and so under the EB5, you said they invest in a company. Can it be any company?
It has to be what is called a new commercial enterprise.
So it sounds like it can't be investing in an existing business.
Well, it can be, but only if it meets certain conditions.
And what are those conditions?
It is rather complicated, but simply put, there either has to be a company restructure or the investment increases the business by 40% or more.
Okay, are there any other qualifications for the business?
It must be a for-profit organization, so no nonprofits.
Okay, so that means it can't be a charity.
That's right.
And you said that they have to invest money. Is there a set amount that they must invest?
There are. Currently, there are 500,000 in specific rural areas or 1 million for more urban areas.
And why the difference?
Part of the goal of this program is to help increase jobs and the economy in the United States so that the areas that are depressed, meaning not very good in jobs and income, there is an incentive to invest there by reducing how much you have to invest.
Okay, and do you also have to pay filing fees if you're investing such a big sum of money?
Yes, you do. As of today, August 13, 2019, the filing fees are $3,675 for the Form I-526.
And how long is your visa good for?
Initially, as I said before, it's good only for 2 years.
And can you extend it?
No. What you must do is to apply to remove the conditions from your permanent resident card.
And so it's like if you got married and you got a green card, first you get a green card that has conditions on it, right?
Yes.
Okay, and so now you wanted to talk about the changes to the EB5 rule.
That's right.
And so tell us about them.
Sure. So I mentioned before that the investment amounts were 500,000 or $1 million but when this rule goes into effect on November 21st, 2019, the investment amounts will be higher. The standard minimum investment will be 1,800,000. And the TEA, which is the Targeted Employment Areas investments, increased to 900,000 from the 500,000.
Okay, and what about if people already applied and their application is pending? Are they going to have to invest the higher amounts?
No, these changes are for people who apply after the effective date.
And that seems like a pretty big jump to me. So from $1 million to 1,800,000, or $500,000 to almost $1 million.
It does. But keep in mind, this law went into effect in 1990, and the amounts haven't changed since that time. That does bring up another change. The new rule says that the amounts will be updated every 5 years for inflation. So they said that the increases are only based on inflation.
Okay, so $1 million to 1.8 million, or 500,000 to 900 is just because of inflation from 1990 to now.
To now.
Okay.
That's what they said.
Are there any other significant changes?
Yes, the TEA designation is moving to the Department of Homeland Security from the State Economic Development Centers.
And why is this significant?
Well, the EB5 program has been well known for corruption. Those with the biggest pockets, who could bribe officials, were getting visas, and those trying to follow the laws weren't. So this is supposed to help stop that.
Okay, any other important changes?
Yes, another very important one is going to be a change to priority dates.
What does that mean?
Remember, we've discussed this in other videos. Your priority date is the date USCIS receives your application. And the processing of your application is tied back into that priority date. With the new EB5 regulation, an investor can retain the priority date from an approved I-526 petition as long as A, USCIS did not revoke the earlier approval based on the investor's fraud or willful misrepresentation. B, USCIS did not revoke the earlier approval based on a material error. And C, the investor has not been admitted to the United States as a conditional permanent resident.
So I'm not sure I understand. If someone has an approved I-526 and then was admitted to the U.S., why would they need to get a new priority date?
Again, this is a very broad information that we give you right now for a very complex subject. But there are a couple of steps that we've already talked about. One, you have to file an I-526. This is approved when a visa is available, and this grants you a conditional green card. Two, you move to the United States, and within a certain time period, you must apply to have the conditions removed. The business must be successful, including that it creates a certain number of jobs for U.S. citizens. And if it doesn't, you must apply again for a new I-526 and return to your native country until a visa has become available, presuming you're approved. So when you do that, your priority date changes to when you applied for the second I-526. So since there are a limited number of visas available, you may be kept outside the United States for a significant amount of time, 5 to 8 years, depending on the country of origin. There is a bill that has been passed by the House that would increase the number of visas available for certain country, hopefully to reduce processing times. But with so many bills not being voted by the Senate because of Mitch McConnell stopping them, this may not be passed either.
Okay, and what do people think about the changes to this new rule, or the new rule, I guess?
One of the biggest concerns is that is with the big jump in the investment amounts. People will go to other countries then that won't require such a large amount in order to obtain a visa. Plus, those countries are usually much faster at approving applications than the US is right now. The US can take up to 5 to 8 years, and other countries only take 6 to 9 months. Also, with the TEA designation, moving to the Department of Homeland Security, there is a concern that people will experience bigger delays and additional costs for investors. Interestingly, DHS claims that these regulation changes will increase EB5 applications when the last 3 years have seen a significant decrease in this application. In 2015, there were 14,373 EB5 applications, and in 2018, there were only 6,424.
That's a huge decrease, right?
It's a huge decrease.
Yeah.
Yes.
Any other criticisms?
Yes, this program was started to benefit states, especially those with depressed areas. And since DHS is now going to take over the TEA designation, many critics see that this will further hurt the states. Also, since EB5 applications have decreased significantly, and there is nothing to suggest that the slower processing times and increased costs will increase the number of applications, we can only presume that states will be hurt for them.
Hey, any good news?
Yes, a few things. One, rural areas, less developed, should see an increase in business based on EB5 applications because the urban city areas are not going to be able to qualify. Also, spouses and children who obtain a conditional green card can now apply to remove conditions regardless of if the applicant applies to remove the conditions. And if the House bill that we mentioned above passes, then investors from China might see a reduction in wait time of 3 to 5 years. And going back to explain how the spouses and children can apply to remove the conditions. Before, spouses or children who came with the primary applicant could only have conditions removed if the primary applicant applied for that themselves. But with this new rule, even if the original applicant doesn't apply to remove conditions on their green card, their spouses or children can apply to do so on their own green card.
Okay, anything else?
Yes, there was a management requirement for the principal investor. So a certain level of participation in a day-to-day business, and that is no longer the case, and it can be a much more passive role.
Okay, so any advice for those considering getting a visa under the EB5?
Yes, if you're not able to get your application in before November 21st, 2019, you should get all your immigration documents in order. And this includes the source and path of any money that you are going to invest. And ensure your project is located in a designated TEA before applying. And one thing I want to point out is that, as we have discussed before, any immigration rules must be authorized by Congress. Regional centers, also known as immigrant investment programs, have to be reauthorized by Congress or they expire on September the 30th, 2019. That is almost in a month. If they are not authorized, this new rule may not go into effect. However, keep in mind that these regional centers have been approved every year, so it is unlikely they won't be approved again. Thank you so much for everyone who is watching right now, and for everyone who's going to watch later. The EB5 visa is complicated and not everyone can qualify, but I have helped clients before who were approved, and I would be happy to meet with you to discuss further to see if you are eligible. Please call our office to schedule a consultation. As always, we are always here to help. Thank you.